Jai Hind everyone, welcome to the Patriotic IAS. Let's start our discussion on the Hindu news analysis. Before entering into the discussion, I would like to request you that please all of you try to subscribe to the Hindu newspaper. And yes, I will not ask you to subscribe this channel or that channel, but yes, the Hindu deserve and they work lot of means they involve lot of resources and they work very hard to bring the quality newspaper and only few people that has the quality production. So please respect their hard work and yes, you should subscribe to the Hindu. This is my humble request. So we will come on the topic. We will start with this first paper. And this first news is very important. This news involves so much concept and also this is very sensitive and serious issue. And there has been a lot of controversy with respect to this news. I will bring the context of this particular and this is not my story. This is available at the Supreme Court website. That what was the context of this Bilkis Bano, on the name of which this case is, the verdict is based. She is the victim of the Gujarat riot. Gujarat riot took place in 2002, and it was time when our Prime Minister Narendra Modi was the Chief Minister of the Gujarat. Two communities fought with each other. There was so many enmity between two communities. In that context, the family of Bilkis Bano living in a village, they find that it is not safe and they try to leave their village and go some safe places. While she was doing so, they were chased by the mob and in the way they were brutally killed. All the family of Bilkis Bano was killed in the way when they were shifting, and also her 2-month daughter was killed. Even she was assumed that she is dead, and that's why the mob left, considering also the Bilkis Bano as the dead, and she was also raped. But after one day, she got conscious and she reached to the police station. Police was not ready to register the FIR, and after so much insistence from the Bilkis Bano, police registered. Even after registering in many of the, in that particular, during the registration, they skipped many of the name mentioned by the Bilkis Bano. When the trial starts, there was so many threat call to the Bilkis Bano, and she approached to the Supreme Court for transfer of this case from the Gujarat to the some other state because it was being done in the Ahmedabad, and she requested to the Supreme Court that she is not sure that whether this she will get the justice in the state. So that's why Supreme Court transferred this case to the Mumbai, and it was brought under the special CBI trial court. During this trials, as the final result verdict, this CBI court sentenced 11 of accused, and 7 of accused were uh, 7 of accused were released. They were not found. Particularly, there was lack of evidence with respect to these 7. After that, these convicts appealed in the Bombay High Court. Bombay High Court upheld the conviction, and they didn't give any relief to the convicts. So this was the process. After that, there is these convicts, after spending in the some amount in the jail, they approached to the state government for a remission of their sentence, and yes, state government provided remission to these convicts, 11 convicts, in mass manner. This remission was criticized across the country because of that the nature of the heinous crime. Generally, this remission or the pardoning power that we will discuss pardoning power of the president or governor is provided in the case that it is only in the case, means mostly in the case is provided that when some crime has been committed and by the court there was the error in the justice, some error occurred, and later it is found that the yes, those who has been convicted is not the culprit, he is the innocent person, and so to bring the justice, this power has been given to the president and governor. This is just a relief provision, egalitarian provision to bring the justice to those person who are convicted due to the error or the some of the other situations. So it is basically provided on a humanitarian ground. But if you are providing remission to the those who are convicted in such a heinous crime of the riots, murder, rape, so this is not justified. So Supreme Court again has again under this verdict that came yesterday has criticized the state government as well as criticized the central government for giving approval, because whenever there is the law associated with the central government, CBI was associated in this case. That's why approval of the central government was needed and central government provided. This is the background, but the concept that is relevant for you is the concept that we will discuss, and those concepts, let me mention, we will discuss pardoning power. Already we have discussed, again we will try to revise pardoning power. Okay. Second thing we will discuss, rule of law. Third, liberty. These are the concepts that we will discuss, and we will also bring the criminal procedure, while we were discussing. So let's start, as all this has been mentioned under this verdict, that Supreme Court had criticized that the rule of regulation will be a rule of law will be always prevail over the liberty. It is not that for the providing some personal liberty we can compromise with rule of law. So rule of law has been upheld. Second thing, it is mentioned that it was the criminal procedure code that was violated. Okay. What is the pardoning power? Pardoning power is provided to the president as well as governor. For the president, it is provided under Article 72, and for the governor, it is provided under Article 161. Under the pardoning power, there are the different category. The first category is the pardon. Second is commutation. Third is remission. Under that, these 11 convicts were provided with the relief, and fourth is respite, and fifth is reprieve. There is minute difference among each of them. Pardoning. What is the pardoning? So pardoning means totally absolve from the sentence, punishment and disqualification. For the death punishment or some of the capital punishment. So it doesn't only reduce the sentence or eliminate the sentence, remove the sentence, it's also remove the conviction itself and associated disqualification. For example, whenever you disqualify with the some of the heinous crime, you are disqualified for the contesting for the elections or the uh, owning or being at the some of the constitutional or the statutory post, or the you are disqualified for the employed under the government. So if it is provided under the pardoning, you will be also, this disqualification will be removed and you will be eligible for the those all post that is eligibility under the normal law. Okay. So it is the death punishment, and you should also be very much clear that under the 72, when the president is providing the pardoning and this all the other relief, it is for the union law as well as for the martial law. And for the death sentence, governor cannot provide the relief of the this pardon under the 161. Death pardoning for the death is always associated with the president of India. And the governors provide this reliefs pardoning relief under 161, and it is for the state laws. Then commutation come. Commutation is like the transferring or the, making a transfer from the higher punishment to the lighter punishment, harder punishment to the lighter punishment. Like the, you can be harder to the lighter, harder to the lighter, lighter. For example, you have a punished with the rigorous imprisonment, so it could be changed to the just imprisonment, or the from the death to the life sentence, means harder to the lighter. So it will be under the commutation under the normal cases. The nature of punishment will change. Remission, it will reduce the time period, reduce time period or the duration or duration. For example, if you are convicted for the 10 years, it under the remission it could reduce for the 6 years. So it is just to reduce the duration or the time period, but it will not change the nature of punishment. It is not that the death is converted to the imprisonment. Is it clear? Respite. Respite is same as the remission. It is all no. Respite is same as the commutation. It changes the nature of the punishment from the harder to the lighter, but actually this is provided in the special condition, just such as when there is the woman and there is a pregnancy, or there is a person who is with the disability. So in such cases, the harder punishment is converted to the lighter punishment. Okay. The reprieve is provided in the case of the when a convict has appealed in the Supreme Court or the higher court, apex court, or to the governor or the president for the pardoning, and think that you are a person is convicted for the death sentence and he has to he is about to hang on the 9th and on 9th January today. Okay, he will be hanged, but suddenly we find that he has applied for the pardoning or the reconsideration of this conviction to the higher apex court. In that case, the person will be not hanged on the 9th. He will provide it time so that the apex court can hear and provide some relief if possible. So the date will be changed, everything will remain the same. So this is the reprieve. I hope this is clear to everyone. Next concept that is that has mentioned here, that the rule of law doesn't mean that protection of a fortune few. It is it cannot be compromised despite whoever is there. So you should understand what is the concept of rule of law and what is the liberty. Rule of law. The concept of rule of law. It was proposed by the A.V. Dicey. And as per this rule, there is three things comes under the rule of law. First is the absence of arbitrariness. Absence of arbitrariness or arbitrary power. First is the absence of arbitrary power. Arbitrary power means if a person say and that's become the rule. Means if there is a king, he says that that person, I doesn't like that person, he should be hanged. Arbitrary, there is no reason. There should be the reason that if a person is doing something wrong, then he is punished. But arbitrary means just you want and without any logic, that should be the done. For example, Hitler doesn't like the Jews and he ordered for the killing of the lakh of Jews. So this was the arbitrary power. There should be always responsible power. So absence of arbitrary power. Second is equality before law. Equality before law. Equality before law means every people, every person is equal in the eyes of law. It is either Prime Minister, President, Ambani, or a poor person pulling a rickshaw puller or the working in the field. They all should be treated with a common law. For example, if I will murder someone, if the punishment for this is 10 years, and if it is Ambani or the Adani or the Tata, anyone killing a person, the sentence still will be 10 years. Is it clear? So absence of arbitrary power, equality before law means everyone is equal in the eyes of law, and third is supremacy of individual right. Supremacy of individual rights. Means if a person is provided with the basic rights, fundamental rights, it will be not compromised until and until there is very some dire situation is there, very serious situation is involved, and also this individual rights will be violated with the logical some procedures, some law established by law, and there will be always a judicial scrutiny on that. So these three things should always prevail, and that's make a rule of law. For the any society to conducted in a orderly manner or peaceful manner, rule of law is very necessary. Whenever rule of law is compromised, the whole society will not be peaceful. There will be the chaos. Second thing is the liberty. Liberty means freedom to do, and particularly to improvement of your character or your personality or to achieve something you want to, that's freedom. But it's always comes that your freedom, your liberty shouldn't violate the other, and always you have to follow this liberty with some rules regulation within a proper framework. For example, if I give you liberty to listen a song, it doesn't mean that you are listening a song that is going to disturb your neighbors. Your liberty to listen a song is only it will be intact, it will be followed only until you are going to disturb or violating the other's liberty or the rights. So liberty always comes with the some of the reg- regulation. This is within a law, and it should not be. If liberty is provided in unrestricted manner, those who will be powerful can do anything. For example, if I will be a Bahubali or the powerful man, I will do everything. All the neighbors will not raise their voice. So, and always I will prevail. I can do anything, but others will not able to object or not able to live their life in a peaceful manner. So liberty comes with the rule of law. If there is the rule of law, only then liberty of every person will be safeguarded. One famous quotation is that if there is no law, there will be no liberty. So to establishing a liberty, Law is always necessary and rule of law becomes very crucial that this judgment mentioned. Also this article mentioned, this judgment mentioned that the Gujarat was not appropriate government under section 432 7b of the Code of Criminal Procedure. I have already explained in previous discussion that what is difference between IPC and CRPC. IPC is particular mention the punishment with associated with a different uh, offense committed or the crime activity is done. It's talk about the punishment, but the criminal procedure law it's describe how the this all process to reach this justice or the punishment, like the court trial. After the court trial, how these convicts will be provided with the different areas of relief such as the parole and other thing. So all this has been provided under the criminal procedure code. So punishment is under the punishment is under the IPC, and procedure to follow the trials and other thing will be under the criminal procedure code. So all this is mentioned has been covered under this article. One thing is that the remission policy is followed by the state government with their own scheme. So different states have different scheme with respect to this. So this means this verdict also mentioned that this Gujarat High Court, this Gujarat government that followed the policy of 1992 is not valid, was not applicable to the Maharashtra. Next important news, this controversy that is going between the India and Maldives. One thing I found important is that it's as we are being discussing this Lakshadweep and the Maldives. So you should know that what is the channel that divide Lakshadweep from the Maldives. It is the 8-degree channel. So 8-degree channel, that is latitudes that divide the Lakshadweep from the Maldives. Second thing you should know that if you are talking about the Lakshadweep, we have also other important island, that is the Andaman Nicobar, and here the 10-degree channel separate Andaman from the Nicobar. So this 10-degree means, and this 8-degree, it means that the position, the location of these two islands with respect to the latitude. Those who have the political science and international relation as the optional, you can use the name of Foreign Secretary Nirupama Rao whenever you are giving some view with respect to the India-Maldives relations. She has mentioned that the foreign relation and the practice of the diplomacy are easily eroded by the ill-advised remark made by irresponsibly by person in the public domain. So whenever a person has at the some important position, constitutional position, their statements should be weighed before they speak anyone, because if they are speaking something, because there has been the chaos between the relationship between the India, Maldives and Israel has also came in the support of India. So you should whenever a person is taking any of the statement, making any of the statement, he should be careful that how he is going to impact the life of others. Now it is making a threat to the tourism industry of the Maldives, and there could be the further worsening of relation between India, Maldives, and also Maldives and Israel. This news is with respect to the recent this guidelines provided by DGCA to the for the pilots. Now we have seen there has been the many accident in the airlines, like the recently we saw there was this accident in the Japan, two aeroplane collided. So it was found that it was the large hours of the working hours for the pilots. They were working for the night shift, day shift, and consecutive one shift to the other shift. So they were not able to sleep properly, and that's why many a times when the direction comes that you don't have to fly this particular time, they miss that, and in that case, when they fly, there is the chances of the accident, as we saw in the case of Japan. So now the number of consecutive working a night shift has been reduced from 6 to the 2. This is here. This has previously it was 6, now it is 2. For the 2 consecutive day, it means that if on the Monday and Tuesday the pilot was given the night shift, Wednesday they should not be provided with the night shift. They should avoid. And here it has mentioned the circadian law. Circadian law means this is time period. Circadian time period is that particular time where the we human, as a human cycle, we have a particular fixed time when the body do not respond. At that particular time we are lowest in our energy. That is particularly between the 6 uh, 12 in midnight to the 5 or 6 into the morning. So this guideline has increased from previous 5 a.m. to the 6 a.m. This period of night's duty, that is the definition of the night duty, and the upper ceiling is increased from 5 to 6. So circadian law will be defined between the 2 to 6 or the 12 to 5. This is something you should know. The Golden Globes, this award is given to the film producer, directors. So this is important with respect to the state pieces, that they ask that best actor award this year, best actor award in the Golden Globe is given to whom. So it is the actor of the Oppenheimer, Cillian Murphy and Robert Downey Jr. They were provided with the Golden Globe Best Award, Best Actor Award, Actress Award to the Gladstone for her picture in the Killers of the Flower Moon. So you should remember this Killer of the Flower Moons. You should also you can watch the trailer so that you can retain it for the longer time. I think most of you have watched this Oppenheimer. The beef, this is not to eat. This is for to particularly watch. Okay, so here it is for the movie. It is given to the best television limited series. So you should also know. These are for the general information for the state pieces. The next important news that is relevant for us is this. Karnataka High Court bans mining activity near the KRC reservoir. So you can use it under the court intervening in the environmental protection measure. And also you should know that this Krishnaraj Sagar dam, this is associated with the Karnataka and its location. So let me show the location of Krishnaraj Sagar dam. This is here, Krishnaraj Sagar dam. It is near to the Baba Budan hills. This is known for the iron ore. So you should know this Baba Budan hills. They are mineral rich area, and Krishna Sagar is associated with the Karnataka. Dam Safety Act was brought in 2021, so you should remember you can use this as the fodder point wherever the question comes on the. This news is important. Coffee plantation, it is talking about the Bhadra Wildlife Sanctuary. So one thing, it gives idea that the coffee plantation occurred in the this Karnataka as well. This is the physical map of the Karnataka. And this Bhadra reservoir is situated here, just near the Baba Budan Hills. You should remember. It will help you whenever you will see that Karnataka coffee plantation. Yes, correct. Mysore Reserve extension where the wild elephant roams. So this elephants are found in this area. Elephants are found in most of the reserve forest area of the Karnataka and south. Overall south. Okay, this news is related to the GS paper 3 internal security. Again, you can use in the now we have started the crime and criminal tracking network and system. This is the modernization of the policing system, and under that it has provided that the still there is some of the issue that is facing. Some of the example is that there is the devices that is being provided to the police is not sufficient. As one of the example provide that there was a case where the police went and they tried to record the video of the videography of the crime, but due to the lack of the data that was provided in that particular camera, the recording ended in the 20 minutes, but the crime scene, crime activity events go for the longer. So it was not sufficient. There is also threat to the data, and as we are going to store all the data, a lot of data is going to generate and it will be on the cloud system, so there is always chance of the threat of the hacking and other such criminal act. There is also chance of the pilferage of the data. Whenever there is the pilferage of the data, though that is misused by the those who are involved in the court cases. So this is other drawback that we need to work for the justice system to efficient working of the justice system. One of the issue that has been found that despite we have shift to this CCTNs, but the still online filing, the charge sheet, case diaries and investigation is not that much effective as the data is showing. What are the critical infrastructure? Particularly critical infrastructure are those that involve the very crucial services like the health service, power services. They are, if they are hacked or they are compromised, whole the nation activity will become to halt. So their safety is at most important. This article also talk about the free movement regime that is on the India-Myanmar border, and the movement from the border to the 16 kilometer to the Myanmar side and the Indian side of the local community is without need of the visa, so it is permitted, so you should know. Assam Rifle is involved as the counter-insurgency and the border guarding at the northeastern border, so you should know this thing. Next news, this is again with respect to the cookie and this Jo community, Chin community that is in the Myanmar side. We saw yesterday in the map they are distributed in the Myanmar side as well as the Mizoram, Manipur, even in the Bangladesh side. Meaty Pangalas, they are the meaty Muslims. Just you should know who are they. Here it is showing that what is the process. One of the process in the process of adding some community in the ST list, state government recommendation is also needed. So this comes from this. Yesterday in the previous discussion, we saw that if you belong from the person, a community belong in a ST list of the one state, and that person is going to apply for the other state some job and some scheme of the other state. So if that community is not eligible, are included in the list of SC list of that state, they will be not eligible. For example, if a person is in the SC list of ST list of the Tamil Nadu and he is going to apply for some job, state vacancies of the Karnataka, and in Karnataka that community, that person is not in the ST list or SC list, then that will be not eligible for that post. You should remember this thing. Next thing you should know with this respect to DRDO recent development, it is achievement in the science and technology, and DRDO has developed the toughest medium altitude long endurance UAV, and this will be helpful in intelligence, surveillance, target acquisition and reconnaissance application. Means data and other information will be gathered from the distance place if the activities is happening in some place. For example, if there is some Maoist activity in the forest area, so UAV will go and capture all the information like their movement, their number of the arms and other things, so that the attack from the security side will be easy. Same can be done on the border area as well. This is important. One thing more you should know, this nickel and cadmium and silver zinc batteries has been used. So you should know that this nickel, cadmium and silver zinc is used in the battery technology. If the question comes and the statement is this, that nickel, cadmium and silver zinc has used in the battery technology, that statement will be correct. Next relevant news for us. This is the related to the Collegium System, GS paper 2. You should know that what are the way judges are appointed under the Collegium System. Chief Justice and 4 senior most judges form a committee that is known as the Collegium, and they give list name of those recommend the name of the person who could be appointed eligible for the position of the judges, and after that president appoint those person as the post of the judges and chief justice of the high court. So in the case of the high court, there will be the 2 senior most judges in that collegium. Okay, so you should be clear. We will read all this thing in the our polity paper, a polity topic again. One more thing you should know is this 99th Amendment Act was brought to bring the National Judicial Appointment Commission, because there was the accusation that collegium system has become a bit example of the favoritism and nepotism. Means there was the cases that if I am the judge, there is the tradition like the I will appoint son of you. There are 4 judges. They will decide that such allegation is there, as this line is mentioning, that I will appoint your son and daughters. You should appoint my son and daughters. All will become judges. No internal entry is that. This was a good initiative, but there was the one flaw that government was equally participating in this commission. That's why it was compromising. Means we should not transmit from one batch system to the other batch system. So Supreme Court in its verdict under this collegium, the NJSC verdict, they said that by this commission, this amendment, the independence of judiciary will compromise, because in the commission half of the representation was representation was from the government, and law minister was also part of this commission. That's why Supreme Court strike down this verdict, this act, this amendment. Okay. Next, now this news is related to the GS paper 3, science and technology. We have recently seen that lot of claim that has been for the declaration of element, that research papers and different scientists is claiming that they have found the metal that can show the superconductivity property at the normal temperature. What is the superconductivity? Here it is talking about the superconductivity. Superconductivity means when there is the flow of electricity in our house, everywhere there is the electricity that is working, and electricity is flowing through the wires. So whenever electricity flow through the wires, there is the resistance of these particles, and that turn into the losses. So if we are sending 100 amount of the electricity, due to the loss, we are only able to utilize 60% of that. So 60%, 40% is turning into the loss. So it is considered that if the superconductors if we are able to find the superconductors, they could reduce the loss, and that's why we can save loss of money. So that's why there is the huge benefit if anyone is going to find or invent this superconductor on a normal temperature and pressure. Why I am talking again and again normal temperature and pressure? Because on the extreme temperature, like the extremely low temperature and extremely high pressure, already we have we have invented many metals that shows the property of the superconductor, but we have not find any metal that shows its superconductivity property at the normal temperature and the pressure. This Meissner effect is associated with the Meissner effect, as it is represented by if there is the transition to its superconducting state, the material is changed to its superconducting state, the material will expel any magnetic field in its bulk to the surface, and that's why it will be floating. Okay, so that was particularly, that is very clear from that video. You just need to know this Meissner effect is associated with the superconductivity. You don't have to go into the detail because it will become very much complicated and not relevant for the UPSC. Hysteresis loop, it is again associated with the superconducting process when there is the magnetizing to the material. So by one way it's become the material in itself become magnetized magnet, but the reverse process is not possible. Once it's become the magnetized, despite to remove the magnetization process, still that metal will be magnetized, and this loop will be known as the hysteresis loop. I hope it is clear. This news particularly with respect to the Swiss company that is has started the offsetting by the providing the credit, carbon credit. So what is the offsetting? It is associated with the Paris climate. Offsetting means whenever you are doing more and more emission, your company is emitting more and more CO2 in the environment, it's hurting, impacting negatively the environment. As per the Paris Convention, Paris Agreement, companies are, the countries are obligated, and thus the companies are also obligated from the nation itself that you have to reduce some lesser amount of the CO2. So they have, if you, one options alternative has been given that if you are not able to reduce the CO2, you should pay for the those company who are producing less energy in the very less amount of the CO2 emission. So like the, it is like the, it is like you are, what could be the example I can give? Offsetting is like compensation. And here the carbon credit is defined equivalent to the reducing 1 metric ton of the carbon dioxide with the 1 credit. So there is the debate that this definition is not properly standard form. There is the vagueness in this definition. This process is also criticized that you are allowing the pollution if you are able to pay. So this is like the, if you are able to pay, you can do the crime. This is like that. So this is being criticized. More simple word, if I will explain that, कि अगर आपके पास पैसे हैं तो you can do the crime. This is this is being equated by that. Means if you are able to pay, you can emit more and more. So this is not going to do a ideal solution. This editorial again is talking about the Gujarat Bilkis Bano case, and here the statement of the justice has been provided that it has clearly mentioned that the Gujarat acted in the tandem and was complicit with the convicts. Ruling represents a blow to the rule of law and the restoration of the faith in the judiciary at the time when there are doubt. Actually, this line is talking about that when there is the very tough situation, when the government is in the majority and the judiciary is not able to hold the accountability of the executive organs. In such a situation, if this verdict is there, so it is putting the faith in the people, in the check and balance system. One more thing that has violated, that this mentioned that for the remission process scheme, it is need that the convict should spend at least 14 years in the jail, then remission is provided. But in this case, it was the convicts were not were not crossed this 14 years. They were less than they spent less than 14 years, despite they were provided with that remission scheme. Here, other uh, here the way forward has been provided that there should be the proper guideline that if there is the remission is being considered for any convict. So what should be the kept in the mind, the whether the crime involved affect the society at large. It should not be that much heinous crime. The second thing is that what is the behavior of the convicts and whether they are able to reform, we are able to reform or not. All these things should be kept into the mind. The second editorial is not relevant because it is associated with the political development in the Andhra Pradesh, and the sister of Chief Minister of Andhra Pradesh, Jagan Mohan Reddy, Y.S. Sarmila, has joined the Congress, and the dynamic situation has changed. Political dynamics has now changed into the Andhra Pradesh. Associated with the recent laws that we have replaced and changed. For example, we have changed the IPC with the Bharatiya Nyaya Samhita, Indian Criminal Procedure Code with the Bharatiya Nagarik Suraksha Samhita, and Indian Evidence Act with the Bharatiya Sakshya Samhita. And there are many there are many acts that we have replaced or amended. So this is talking about that it is good that it is common perception that if the law is not that much useful or become redundant and old and creating a hurdle, it is duty of the state, and also it is duty of the people, citizen, moral duty of citizen to oppose unjust law by all democratic means. Even it is the statement of Gandhiji during the civil disobedience movement. So it is talking about the law can be changed on the two contexts. First is it has become outdated. Second is the altered perception of law and itself that treat law as the power resource. Okay. These changes of the laws recently has been brought under the Jan Vishwas Amendment to the Provision Act 2023, and it has replaced and amended 42 center law. So whenever you give the government effort and steps, so you can bring this steps taken by the government in your point, and it is pointing out 3 points where this law will help. Outdated rules and regulation are anathema to democratic governance. Second, it will reduce the compliance cost and burden, and it will enhance the cost of living. And third is that there is always fear into the businessman that if they will do any thing and that will not as per the law, they will face the punishment. So this create a resistance to take new steps, new initiative. So this change in the law will help in that. But the issue is with the second perception, that power resource. And in this case, whenever you do this thing, change the law and interpret the law, particularly under the pressure of the command group, majoritarian tendency, and you make them happy, populist measures such as the police encountering or the bulldozing the buildings. So it's give the instant and immediate justice. But many a times, if you do not follow the rule of law, it's create a issue and chaos in the society. At the initial stage, it could be good, but many a times in all the cases this is not reaching to the justice. In just reaching the justice will become a chance, and it has provided the case where such justice we have seen. There is the shooting of a young car mechanics, there was the protest, huge protest in the France, and other case from the India, there was the recently terror attack in the Kashmir Punch district, and after that army just arrested few of the civilians, and there was the death of civilian and the torture case was there. So the writer is talking that this This type of the justice that is on the populist measure, they are not reversible, and it's many a times result into the justice, and it is not good for the society. So we should be avoiding such things. You can use this in the philosophical essay as well. Please answer this. This has been asked on the UPSC 2020 2018 based on the concept of liberty and rule of law. Which one of the following reflect the most appropriate relationship between law and liberty? Please answer. So you can see that how UPSC asks the conceptual question. So the answer for this question is B. If there is no law, there is no liberty. As we know that to establish liberty, there is need of the rule of law. Already we have established. But other concept is also very similar. It will give you a sense that yes, it is also true, but this is not true. Many students got confused. Please answer this question again on the rule of law asked in the 2018. Rule of law. So as we saw the rule of law, you can eliminate third as the AB Dicey, the concept it's talk about the absent of the arbitrary power, so limitation of the power, equality before law, 1 and 2 is correct. So 2 is here, 2 is here, 2 is here. 1 is also correct, so either it will be C or D. Then you can reduce this people's responsibility to the government. This is not. So if you will eliminate 3, you can eliminate this and this, and 1 is here, so it should be the C. C will be the correct answer. Again, question on the liberty. In the context of polity, which one of the following would you accept as the most appropriate definition of the liberty? What? So liberty is provided as opportunity to develop fullest oneself fully. Okay, so this D will be the correct answer. This is for you. Please write the answer for this, or it will be a practice question for you. As we are continuously reading about the replacement of the 3 law, and we will further read replacement of the 3 laws. This article is related to the new guideline that has been provided by the UGC, University Grant Commission. So it is talking about the how this want to inculcate different values, this guideline, and it is under the Mulya Pravah 2. So you should know that what is the Mulya Pravah 2. UPSC can ask the question. Mulya Pravah 2 is related to the education sector, health sector, uh, trade sector, trade policy, or any other areas. So you should be clear about this. Mulya Pravah 2 is associated with the this reform in education, particularly college and institution, the way they work. So the main aims and objective of this is to inculcate human value and professional ethics in the higher education. And for that, it also talk about it's want to bring the deep respect for the fundamental duties and constitutional value. Recent data from the different surveys, it has found that in the organization and institution, these are the things that is prevalent, such as the favoritism in hiring and training, promotion in the promotion. Favoritism is a very common thing. Other thing that is common is this sexual harassment at the workplace, and also gender discrimination in promotion. All this has been provided. You can bring this point that these are the things that is impacting lack of confidentiality, gender differentiation in compensation, arrangement with the vendors for the personal gain. This is the source of corruption and gender discrimination. So these are the things that is being and this particular guideline want to prevent all these things. So this is good initiative at the UGC want to bring such thing. But the thing is that until and unless you are not going to implement on the ground, that is the affecting, that mainly do the difference. So there should be the zero tolerance as the suggestion, and this regulators should act swiftly if they find any case of the corruption in the admission, examination, hiring process, all this area. This new guideline Mulya Pravah 2 want to bring the transparency in administration, and this highlight the decision making in the education institution must be solely guided by the public interest and not by the personal biasness. You should be giving the first preference to the public interest. Ego should be on the back bench or the back seat. So this is the main thing that is talking. It is also talking that there should be the critical encouragement of the critical thinking and the opposite suggestions. If there is the opposite suggestion or the idea, it should come forward. It should not be like the people should be judged. People will be judged if there is some different or that suggestion or his view is opposite to you. This guideline want to ensure integrity, trustship, harmony, accountability, inclusiveness, commitment, respectful belongingness, and sustainability. All these things in the institutions, higher education. However, in the practicality, these all values are receding in this institution. One suggestion is that whenever this particular guideline also want to bring behavior such as the avoiding, not accepting the gift or the its tone into the latter you have to favor. So all these things should be the focal point for this guideline. Here one issue that is being faced with this institution is not transparency. So also there is lack of disclosure of information. So if the information is not provided at the platform, public platform, public will not able to scrutinize and the trust of the public will be not in the institution. So it is suggesting that there should be the voluntary disclosure of the critical information, such as the whenever there is the what is the agenda of the meeting, what was the main proceeding and the minutes of the meeting, decision making, all these things should be provided at the public platform without any request. This should be the voluntary. It will enhance the public confidence. The next paragraph is talking about the this college and institution you can use in the ethics, that they are like the agent of socialization, and the teachers teachers insert lot of impact on the students, particularly like the shaping the behavior of the student, how they dress, how they speech, the behavior, everything is shaped and taken as a role model from the teachers. So teachers should behave in a proper way, and thus it's asked from the teachers to abide by the provisions of the act and the statute, ordinance, rules, policy and procedures, so that it could be communicated to the student as well. One issue that is raising in this article is that this Mulya Pravah is talking about the staff and student union to support the administration, but there is the issue. The union are the pressure group. Pressure group, those the voluntary groups or the association of the members, they are for the protection of the right of the members and interest of the members. So they are not going to always support the administration. And also it has used that they should raise their issue in dignified manner. But the issue is that itself it has not explained that what is the dignified manner. And this particular clause can be misused by police and the administration to silence them. So this is concluded by the you we should try to amend if there is the process, and we should define this dignified manner. The last news we are going to take is this is important with respect to this concept, carbon border tax. So this is a type of the non tax barrier, means it is the tax barrier, but it is going to on the basis of the carbon intensive products. So there will be there will EU has initiated has given a proposal that it will start taxing those products that is the crossing the border, means getting imported into the EU border area, and it will be based on the carbon intensive product. And developing country like the India and other Brazil, South Africa or the Namibia, they don't have that much technology, so their product is many a times get impacted by this carbon intensive product, and that's why it become very costly in the EU. And EU has been the destination of the India's export. So it has been considered as the death knell for the Indian manufacturing sector, because this has been the EU has been destination for the manufacturing products from the India. And this has been brought under the European deal. This intended to achieve the target of 55% reduction in the greenhouse gas emission by the 2030 compared to the 1990 level. So you should remember this carbon bordered adjustment mechanism. This is associated with the EU, and this is this is imposition of the tax on the import in the EU on the basis of the the carbon emission of that particular factory that has produced that, and it has been done under the European Green Deal. So this is mainly, and further, that's all. Most of the relevant area we have covered. Again, thank you for the joining the session. We will again meet for the next day for the next session. Thank you.